Thanks to Indochino for keeping Legaleagle in the air and helping me look fly.
They can have visions of the future or see the dead, and sometimes be uniquely susceptible to invasion by an entity that is alien to them.
Objection.
Finally, jeez.
On what grounds?
How about silliness, Your Honor?
No, silliness is not a valid objection. Object to relevance or object to improper opinion. Silliness is not in the federal rules of evidence. Hey Legal Eagles, it's time to think like a lawyer. And today in a special Halloween episode, we are covering the exorcism of Emily Rose. Now I'd like to apologize ahead of time. We're having some technical difficulties here in my office, and I didn't get a whole lot of sleep last night. I woke up at 3 o'clock in the morning and couldn't get back to sleep, and yeah. So anyway, be sure to comment in the form of an objection, which I will either sustain or overrule, and stick around until the end of the video where I give the exorcism of Emily Rose a grade for legal realism. So, I guess without further ado, let's dig into the exorcism of Emily Rose. So apparently this movie is based on a real life story where a woman who suffered from severe epilepsy had her family call in a priest who administered an exorcism on her, believing that she was possessed by demons or ghosts or something. And during the course of the exorcism, she died potentially of neglect, potentially of abuse. The priest was then put on trial, and this trial is sort of a mishmash of the things happening at the criminal trial for negligent homicide, as well as what may or may not have happened depending on who you talk to during the course of the supposed exorcism.
In the case before you, the evidence will show that the victim had a serious medical condition
Oh,
that
wow.
demanded medical treatment. We will prove that the victim's condition rendered her physically and psychologically incapable of caring for herself.
Wow, so there's a lot of stuff going on in the prosecution's opening statement that is just, it's perfectly realistic in a way that you rarely ever see in movies and television. First, the prosecutor is standing at the lectern, which was set up specifically for the arguments to the jury. He's using notes. Often we get this idea that lawyers should be talking extemporaneously and yelling in front of the jury, when really it's more likely to be like this. He's just telling the facts. And in fact, the specific wording that he used is "the facts will show" or "we will prove." An opening statement is not argument. You're just showing the jury, or you're telling the jury what you think the facts are going to show in the future. And, you know, the tone that he's using is right too. This is a somber occasion. This is not the time for yelling. You're not going to put yourself out on a limb. You're just going to talk about the dry facts that are going to be elicited in a persuasive way. So this actually might be the most realistic portrayal of a district attorney's opening statement I have ever seen in a movie. It's amazing.
This is what she looked like before the defendant began his religious treatment. This is a photograph taken of her on the day that she died.
This is also pretty realistic as well. There's no reason to, pound the table and yell and scream when you have just a very, very powerful visual image. And so a real life prosecutor would absolutely want to use the strength of that particular evidence without trying to beat the jury over the head with it.
I've known Emily her entire life. I took care of all of the Rose girls.
Can you describe Emily as you knew her growing up?
Okay, so this is I guess a family physician. This could be a really tricky witness because on the one hand, they're a medical professional, but on the other hand, they're a lay witness. They've seen in this case, the victim, so they have firsthand knowledge. And it's a question of whether you're calling this person as an expert witness or are you calling them as a percipient lay witness. You can get into a little bit of trouble when you go past the percipient witness into asking them to opine based on their medical testimony. Let's see what happens here.
She was a bit sickly in her early years. She stayed inside a lot, reading, learning music.
How did she feel about going away to school?
Objection, speculation, the witness is not a psychiatrist.
Well, I mean, even if the witness was a psychiatrist, there's no way that she can know the internal mental state of the victim. You can find out about what they said or how they manifested themselves, which might lead to an inference of what they felt, but you can't ask the actual question, how did someone feel or what did someone think? That's totally improper.
Dr. Mueller, what's your position at the University Hospital?
I am chairman of the Department of Neurology.
And after you heard about the dorm room incident, what were your initial thoughts?
Oh boy. So for an expert witness, especially a doctor, you would spend a really, really long time building up their bona fides and their credibility and their past CV, their accolades, their education. You wouldn't just say, what's your position at this hospital, and then dig into their expert opinion. You've got to lay the foundation that, number one, this person is qualified to give testimony in court, so you satisfy the judge. But also, you want the jury to actually believe this person. So you want to build them up so that they believe your expert instead of the defense's expert. So both for legal reasons and for sort of persuasive reasons, you really have to spend a lot of time building up your experts, not like this.
So, suspecting that Emily was epileptic, how did you proceed?
I administered an electroencephalograph.
What did the EEG reveal?
It showed a possible epileptic focus in the patient's left temporal lobe.
Did this require specific treatment?
Yes, I began a medication schedule for Emily with the drug Gambutrol. I also advised regular follow-up examinations and further tests, but Emily failed to keep her follow-up appointments with me.
Did she give any reason for discontinuing these appointments?
Yes, she told me she was convinced that her condition was a spiritual one.
Okay, here you have some really interesting testimony that I think most people would misconstrue. Most people hear an out-of-court statement. This doctor is saying that Emily Rose said this. Well, Emily Rose is not the one who is testifying. And in fact, Emily Rose is also conveying the things that her priest told her as well. All of these things would normally seem like hearsay. They are out-of-court statements, that's absolutely true, and we can't cross-examine necessarily these particular witnesses. However, I don't think this is actually hearsay, because hearsay has to be an out-of-court statement used for the truth of the matter asserted. The truth of the matter asserted is that Emily Rose was feeling some sort of spiritual encounter. Whether or not that is true is not the point of the statement being used. The point of the statement is to explain why Emily did not go back to this doctor and receive more medical treatment. And the point of the statement is to show why Emily Rose went to her priest instead of going back to a doctor. So whether or not she was actually having a spiritual encounter is irrelevant. The point of the statement is to explain the actions of both the victim and the actions of the defendant in this case. So I think that under these circumstances, it actually doesn't meet the legal definition of hearsay.
Did you ask Emily why she had stopped filling her Gambutrol prescriptions?
Yes. She said that Father Moore had suggested she stop taking the drug.
And what, in your medical opinion, was the direct result of Father Moore's suggestion?
I firmly believe that Father Moore's suggestion killed her.
Objection,
Stopping
Your
the treatment
Honor.
led
The
directly
witness
to
is
her
asserting
death.
outrageous conclusions based on pure hearsay evidence.
Technically correct, but I'll allow it as part of his expert opinion testimony.
Oh boy, that was the wrong objection. The problem is not an expert relying on hearsay. Experts are allowed to rely on hearsay. Experts are allowed to rely on otherwise inadmissible testimony to form their expert conclusions. However, this witness probably doesn't have the expertise to be able to testify to the cause of death. And this witness certainly doesn't have the expertise to be able to talk about the legal causation here, which is even separate potentially from the medical reasoning for why Emily Rose died. So that was totally improper testimony. The defense lawyer was right to object, but the defense lawyer made the wrong objection, and as a result was overruled.
Mr. Thomas has contended that Emily Rose suffered from a serious medical condition that required medical treatment, nothing more. He has asserted that any attempt by my client to help Emily by anything other than medical means was not only inappropriate, but criminally negligent.
Well, yeah. Generally, helping people with health conditions involves actually using medical means. So that is a reasonable standard for a prosecution to put out there.
Emily Rose's condition, in fact, was demonic possession. An exorcism was her only hope for a cure. Some of you may find yourself unable to reconcile Emily's beliefs or those of the defendant with your own. You may not believe demons exist. You won't have to, because you will see that after the utter failure of the doctors to help Emily, Father Moore simply tried to help Emily in a different way, using an approach that he, Emily, and her family firmly believed was her only chance for relief.
Yeah, I don't actually think a judge would let that come in. I mean, effectively, you could argue that the mental state of the defendant is relevant, that he legitimately believed that the victim was in some sort of demonic possession. But the thing is, the court is not going to recognize the existence of demons. And in reality, I think what would happen is that the judge would call a sidebar. She would specifically tell the attorney that she's not allowed to make the argument that the demons were actually responsible here. And if the lawyer insisted on doing it, then they would get an instruction at the end that says the jury absolutely cannot make that a basis for their particular decision. It's a weird situation.
Where did you receive your education?
At Yale and then at Cambridge.
And what is your specific area of expertise?
I study the spiritual experiences of people in various cultures and the physiological and psychological changes they undergo during these experiences.
Would it be accurate to say that you specialize in the scientific study of possession?
Yes. Possession is one term for a basic human experience reported by a great number of people all around the world. In my field work, I've seen many people who experienced a sense of being invaded by an entity from the supernatural realm.
Okay, so despite the qualifications of this supposed expert, there are many reasons why this testimony doesn't come in. Number one, I think it's an improper expert opinion. I mean, there is certain scientific rigor that is required to be able to testify as an expert in court. And number two, it's more prejudicial than it is probative. It's more likely to cause confusion and unfair prejudice than it is to actually clarify anything here. This sounds like total nonsense to me.
I believe that Emily Rose was a hypersensitive, a person with an unusual connection to what Carlos Castaneda called the separate reality. Hypersensitives are born different from everyone else.
Yeah, at this point, the prosecution should really be objecting to relevance. Even if the judge lets it in, you need to preserve these kind of things for appeal because this is a total nonsense argument.
They can have visions of the future or see the dead, and sometimes be uniquely susceptible to invasion by an entity that is alien to them.
Objection.
Finally, jeez.
On what grounds?
How about silliness, Your Honor?
No, silliness is not a valid objection. Object to relevance or object to improper opinion. Silliness is not in the federal rules of evidence.
How do you know him?
Well, I was his parishioner at St. Vincent's Church about 15 years ago. I hadn't seen or heard of him for years when he called me last fall. He needed help, so...
What kind of help, Doctor?
He wanted a medical perspective from a psychiatrist, you know, one that he knew and trusted, to observe Emily's physical and mental state.
So, this would be incredibly important evidence to put forward, to say that the priest called a medical professional to supervise everything to make sure that, from a medical perspective, that the exorcism didn't endanger the patient and that she was taken care of during this time. Being able to say that you called a doctor in to supervise everything would probably be the most important evidence you could possibly put on in support of the defendant here. You would not want to wait for that.
Before he was arrested, Father Moore sent this to me. Asked me to take care of it.
Oh. Now remember, audio recordings can be hearsay. If you are recording another person, you are probably recording hearsay. And the tape itself is also considered hearsay. It's a common misconception that things like videotapes or audio tapes or even written documents themselves are just per se admissible. But on the contrary, most of the time, those things are considered hearsay. And you have to have a specific exception to the hearsay rule in order to get those things in. But you also have a chain of custody and authentication issue here to make sure that this tape has not been tampered with and it is what it purports to be. So you can have a really hard time bringing in things like audio tapes into court sometimes.
Father Moore, before you could actually perform the exorcism, you had to get the sanction of the church, correct?
Yes. On October the 27th of last year, I presented my assessment and recommendations to the Archbishop, and he authorized the exorcism that day before I left the office.
So, contrary to what you see in movies and on TV, having the defendant testify in court is actually very, very rare. Mainly because people are really afraid of what might come out on cross-examination. And frankly, the testimony of the accused is probably not going to be particularly helpful.
What do you make of this gesture, this nod in your direction?
What?
I don't know. Some kind of
Well, that's not right.
acknowledgement, I guess, that the game is on.
It is totally improper for the prosecutor to be questioning the defendant right now. Assuming we saw everything that we were gonna see from the defense, it's crazy that they didn't actually ask about the exorcism itself. You are sometimes allowed to ask new questions of your witness. It's called redirect, which happens after cross-examination. But the redirect is only limited to what is brought up in cross-examination. And once you redirect, then again, the prosecutor can recross, but that recross is limited to whatever was brought up during the redirect. So it's crazy malpractice that they put this guy on the stand, made him subject to whatever cross-examination is happening here, but they didn't ask about the crucial thing that they wanted to talk about here.
So this night, when you began to prepare Emily's exorcism, was it your first encounter with this demon ghost?
Yes.
Have you seen it again?
I've seen it ever since.
No further questions at this time.
There's so many more questions that you would ask on cross-examination.
Redirect, Your Honor. Father Moore.
Okay.
After you received the bishop's authorization, when did you proceed with an exorcism?
October 31st.
On Halloween. Isn't that a bit dramatic?
The Halloween tradition is based on legends throughout history that indicate a real increase in spiritual activity on that night, and I thought we could use the occasion to draw them into the open.
Yeah, okay, so this is totally improper for redirect because these are questions that you would ask on the original direct examination. So you don't get a second bite at the apple to go into redirect into these subjects that you didn't bring out the first time.
I offer into evidence this cassette recorder and audio tape as defense
Objection,
exhibits
Your Honor.
A and B.
People were not made aware of the existence of this tape until late last night.
Neither were we, Your Honor. This tape is new evidence that just came into our possession yesterday evening. We have provided counsel for the people with a transcript of its contents.
You mean this tape was not given to you by your client?
No, Your Honor. We received it from a reluctant witness, Dr. Graham Cartwright, who will also be called to testify to its authenticity.
Your Honor,
The people will find his name on the updated witness list we provided to them this morning.
Yeah, okay, so there are a couple big problems here. Judges hate being blindsided, and presumably there have been months since the start of this particular trial. The odds of this evidence being authentic are pretty slim. And to not call the person who provided the audio tape, and when it's not the defendant, those are just huge red flags that this is inauthentic. It's something that's fake. It didn't come from the defendant who allegedly made it. There's chain of custody problems. It's being sprung on the prosecution in the middle of trial. I think all of this means that the judge would probably not allow this audio tape to come in.
Is the defense ready to proceed?
Yes, Your Honor. The defense recalls Father Richard Moore.
You don't get to just recall a witness whenever you feel like it. This defense attorney is getting 3 bites at the apple. They called the defendant once, then they didn't ask all the questions that they should have, and then they called the defendant again to do a redirect examination, which went into topics that were not proper at all to talk about because they didn't bring them up the first time. Then that witness was excused, and they brought the witness back again to testify for a 3rd time. I mean, this is the kind of thing that judges refer to as a circus, and all of this would be improper.
When did you last see Emily alive?
The night before she died, her mother, Maria, called me and said that Emily had asked for me.
Why did she ask to see you?
Why didn't you ask him about this the first time around? Man.
To give me this.
Did Emily explain to you the letter's significance?
Yes. She said she'd written it the morning after the failed exorcism and that it was important for me to share.
So apparently the victim wrote a letter to the defendant before she died. This feels like there's some major hearsay problems here, but let me think about this. I I guess conceivably, it doesn't really matter necessarily about the truth of what's in the letter, but I guess it can go to the state of mind of the priest in terms of the actions that he took, or the actions that he didn't take. Yeah, arguably you're not using the truth of the matter asserted, but you're using it for the effect on the listener and the effect on the mental state of the victim in this case. I think maybe that letter does come in as non-hearsay because it's not being used for the truth of the matter asserted.
Please read the verdict out loud.
In my experience, most times the judges don't make the foreman actually read the verdict because that's a lot of pressure to put on one person. So usually the judge reads the verdict of the jury and they don't put the poor foreperson on the spotlight like this. But, you know, it's dramatic, so it's not surprising you see it like this.
In the case of the People versus Father Richard Moore, we, the jury, find the defendant guilty of negligent homicide.
Makes sense.
The court thanks the jury for its service. Sentencing for this case will be set for April 3rd.
That's also good. You don't see that often in movies. Usually the sentencing is right away, but sentencing is almost always at a later time after some briefing to make sure that they get the sentencing right, because sentencing is totally separate from whether they establish guilt or not, generally speaking.
Your Honor, if it pleases the court, Father Moore requested at the start of the trial that if found guilty, he would be sentenced immediately.
So what? It doesn't matter what he requests.
Does the prosecution have any objection to expedited sentencing?
They should.
Very well.
Sentencing is a complicated thing, and many states and the federal system have complicated calculations that you have to go through to make sure that the sentence fits the crime. And you don't want wild discrepancies between people who have committed exactly the same crime.
Are there any statements you would like to make before I impose this sentence?
No, Your Honor.
Very well.
Excuse me, Your Honor, but the jury would like to make a recommendation regarding the
Objection.
sentence.
That's totally improper.
Sit down, Counselor. It's only a recommendation, and I would like to hear it.
Still.
We recommend a sentence of time served.
Yeah, that is not correct.
I'll accept that.
All right, that is The Exorcism of Emily Rose, and now it's time to give it a grade for legal realism. On the one hand, you have some aspects of the trial that were totally spot on. The prosecutor was using the lectern. They were making pretty reasonable arguments. There weren't a whole lot of histrionics going on. People weren't yelling and shouting and saying you can't handle the truth. So the way that this homicide trial was handled was actually very, very realistic. On the other hand, you have the admission of a whole bunch of totally improper evidence, improper expert opinions, and they completely mangled the way that you would actually have the examination of a defendant being recalled 3 or 4 times in the trial. So all in all, I give The Exorcism of Emily Rose a solid B. Not bad, but I'd really like to exorcise some of the demons. Some of the legal demons. Now, there's no such thing as ghosts, but getting a suit that doesn't fit right will haunt you for the rest of your life. If you're looking for a custom slim cut suit that is shockingly affordable, I can't recommend Indochino highly enough. All of my suits are now made by Indochino, including this blue 2-button that I'm wearing right now. It was custom made just for me. See, the secret to a great suit is all about the fit. I'm a reasonably athletic guy, and I can never buy suits off the rack because they just simply never fit right. I've actually spent more than the cost of an Indochino suit trying to get a tailor to fix an off-the-rack suit before. But with Indochino, you can send in your measurements online, or you can go to one of their stores in person and have a stylist take your measurements. For me, I made an appointment, I went to the store in person and had a stylist work with me for over 90 minutes when I went in for the first time. My personal stylist took my measurements, and a couple weeks later, I got the best fitting suit of my entire life. It was perfect right out of the box. And if it hadn't been perfect, their tailors would have fixed it for me at no cost. Indochino will make you a fully custom suit tailored specifically for you for less than $400. And the best part is they still use the best materials like Super 140's wool. I will never get an off-the-rack suit again, and once you try it, neither will you. Legal Eagles can get any premium Indochino suit for just $359 when you enter the promo code LegalEagle at checkout, or use the link in the description. Clicking on the link really helps out this channel. That's Indochino.com, promo code LegalEagle for the best custom suit of your entire life. So, do you agree with my grade? Leave your objections in the comments, and check out this playlist of all of my other Real Lawyer reactions over here, where I will see you in court.